Hello, and welcome to Litigation Matters, Episode 5. In this episode, I'm in conversation with Rachael Bicknell, Director and Founder of Squaring Circles, as we discuss online dispute resolution. Rachael, thanks for joining me here on Litigation Matters. Talking today, ironically enough, given the title of this podcast, about avoiding litigation and how to avoid the court, but welcome. Thanks for joining.
Thank you.
Now, we've known each other for some time. We used to work together at another large commercial law firm here in Scotland, but for the benefit of those that don't know you, as well as being a solicitor, you are also a practicing mediator, certified online mediator, CEDAR accredited negotiator, and also a member of the Chartered Institute of Arbitrators. So it's obvious, and it was always obvious to me when we worked together, that you had a real passion for ADR. And then last year you left private practice to set up your own ADR business, Squaring Circles. Boasts a very impressive panel of mediators and arbitrators. Some of the names: Suzanne Tanner QC, Angela Graham QC, Pamela Lyle, to name a few. So I'm interested, perhaps you could start by telling us about Squaring Circles, where the idea developed from, and also I'm interested in where the name came from as well.
Well, Stuart, first of all, it's great to see you. So thank you for asking me to come along and talk on your podcast, and even more so to talk about alternative dispute resolution. Funnily enough, choosing the name was the hardest part of setting up the business. The business idea itself was probably floating around in my subconscious for a few years, and it was sort of developed out of my passion, which you certainly knew about, for negotiation, mediation, and generally just finding solutions to differences and disputes without litigating. So Squaring Circles seemed an apt name because it shows the business is about solving problems. When I was thinking about what to call it, I was Googling various different things, and I came across I think it was a philosophical meaning of squaring the circle, or to square the circle. And it talked about to see equally in four directions: up, down, in and out. And that really resonated with me, and particularly all the mediation training I'd had, about seeing the bigger picture, but also looking at disputes from different angles. So once I saw that, that was me. I knew that's what the business was going to be called.
And that was the name set in stone at that point.
That was the name set in stone at that point, yeah.
Well, I was looking at your website, and there was something that struck a chord with me, which is one of the things you put up there, which is that in terms of people facing disputes, in your experience, you say that business leaders rarely, if ever, want to go to court, but that somehow they always find themselves, or inevitably find themselves, in court. And I just wondered, what's your take? Interested in why you think that's the case.
I think there's probably a number of reasons that happens. The main one, I think, is the underuse of dispute resolution clauses in contracts. Okay. So for those who are listening that maybe don't know about this, a dispute resolution clause is one of the most vital provisions in any contract, because it allows the parties to agree within the contract the process to be followed in the event a dispute arises. So a multi-tiered dispute resolution clause is probably the best way of keeping any dispute out of court, because it places a contractual obligation on the parties to first engage in negotiation and then mediation, either as a precondition to arbitration or litigation, or for the parties effectively to contract out of litigating and instead appoint an arbitrator. So, for obvious reasons, dispute resolution clauses are especially important now. The courts and tribunals are facing unprecedented backlogs and delays as a result of the coronavirus pandemic. I mean, you'll have seen in the press, or at least the legal press, this last week, that the Lord President has talked about a backlog of 3,000 criminal cases. Yeah. And a backlog in criminal cases obviously has a knock-on effect, as you know, in civil cases, because the criminal cases are given priority. So, we're predicting it's going to take years for the civil justice system to clear this backlog of cases in the Scottish courts. And that's even before we even think about the predicted increase in cases arising from the pandemic itself. So, anybody listening to this, I would encourage them to think about inserting dispute resolution clauses into their contracts going forward. And there's a number of, speak to your solicitors about, how you do that. There's a number of different resources available online. Squaring Circles has model ADR clauses on its own website. So I think that's a really important thing moving forward.
Mm-hmm. Yeah, no, I think there's a lot to be said for that. I mean, my sort of general impression, and this is only a general impression, but that the dispute resolution clauses, they come at the end of the contract. There's maybe an over-reliance on boilerplates that are maybe no longer fit for purpose, or people get to the end of the contract, the commercials are all agreed, and it's maybe something that isn't given as much thought as it should be. And there are obviously exceptions to that, and I've always thought for a long time that it should be built into sort of corporate and commercial lawyers, ways of working, that they always run these clauses by the litigators, as a matter of course. So I think there's certainly a point there.
Yeah, I think you've hit the nail on the head there, because contracts are being drafted by the transactional lawyers who, as you say, it comes at the end of the contract, traditionally, but there's no reason why it needs to be there. But yeah, it's probably not always given the thought that it should be given. So I think that's probably why we are where we are.
Yeah, no, that's a good point. One of the other things when I was looking at your website that was of interest was, and I've never heard this before, but it's about the definition of ADR. People understand it to be an alternative dispute resolution, but what you were saying, what you were quoting on the website, was that actually that should be defined as appropriate dispute resolution. As I say, I haven't heard that expression before, and I was just interested in what you think the significance of that is. Is it a mindset, and I suppose more broadly, whether you call it appropriate or alternative, what the benefits of ADR as you see them are?
Yes, I think this is an interesting question. So the label appropriate dispute resolution has been coined by those who consider court as the true alternative to more appropriate dispute resolution practices such as negotiation or mediation and arbitration and adjudication. It'll come as no surprise, I'm one of those people. I think there probably is something to be said for alternative or appropriate dispute resolution being a mindset, particularly in relation to negotiation and mediation. In 2020, the Scottish Government are considering the introduction of legislation to bring about, what they refer to as a culture shift in how mediation is perceived. And, I don't know, maybe adopting the word appropriate, would assist with that. But I think the backlogs, as I've already mentioned, being faced by the courts, particularly in Scotland, means that ADR or online dispute resolution, ODR, are now a commercial imperative. These are the things that need to be considered for parties to resolve their disputes, because litigation now is just going to take longer than it's ever done before.
Mm-hmm. We mentioned online dispute resolution, and I think that, certainly in the world we're living in, is a very timely service. I mean, you've mentioned there the backlogs in the courts and knock-on effect of all these backed up criminal cases on the civil justice system, and as we all know, till very recently, at least anyway, the courts were only dealing with urgent civil cases here in Scotland. It's only more recently they've returned to something resembling normality. But again, it's about online and telephone ways to move those cases forward. So I think online dispute resolution is certainly very timely. And I think because of these issues that we've been experiencing as litigators, it has forced us to think about different ways of resolving disputes, forced clients as well to think about different ways to resolve the disputes. And I suppose more broadly here at Shoesmiths, one of the new projects that we've launched is called the New How. And the essence of that is that the what we do for clients hasn't changed. So in my case, my team, we're still resolving disputes for clients, but the how we do it in this new world is very much up for grabs. We're forcing ourselves to think about, is there a smarter, faster, better way to do these things than we're maybe doing before? And our hands have kind of been forced by the current pandemic to do that. So I see ODR, the online dispute resolution, is being very much aligned to that. It's a new way of resolving an old problem, which is how do you resolve disputes? So I'd be really interested to hear about your thoughts on ODR, what you think its place is in this new world we're all living in.
Yeah, well, firstly, I think it's great, the initiative you've mentioned that's running at Shoesmiths. I think that's a great initiative, and I think it shows that you're taking a very progressive approach to dispute resolution, which will be the key to meeting client needs as we, move forward, and therefore, to growing fee income, for example. I firmly believe that online dispute resolution will be at the core of dispute resolution, but also the future of our justice system. In relation to the justice system, it has huge potential to increase access to justice, particularly for low value disputes where the cost of obtaining legal advice are just cost prohibitive. And the savings to the public purse would be huge if ODR was adopted by the justice system. And it's already been used in courts in the US, in Canada, the Netherlands, in India, China, and Hong Kong. I think this is something that I've become really interested in over the last few months. It's important to remember the courts are not a place or a building, but a public service. And the pandemic and the advances in ODR technology provide a huge opportunity to redesign how justice is administered. Anybody with broadband or 4G access and a smartphone can have their dispute resolved or potentially resolved from the comfort of their own home, facilitated by secure and really easy to use technology. In terms of ADR, while social distancing restrictions are in place, we have no option but to adopt online practices such as online mediation and arbitration. But I think the key point is that even when restrictions are lifted, ODR will be combined with face-to-face practices where it makes sense to do that. So already in New Zealand, where there's now no social distancing restrictions, mediators are combining ODR with face-to-face mediation to improve efficiency and to, I suppose, reduce that likelihood, or that certainty almost, for commercial mediations, where it's a given that your mediation day is going to be 12, 15 plus hours. So by combining ODR, you can do a lot of the preparatory work and exploration with the parties privately, and then the actual mediation day, if you still want to call it that, which could be face to face, will be a far more efficient and productive day, which is likely to benefit everybody that's involved.
That's interesting that you're saying about New Zealand, that despite there's been no social distancing now, that they're still using ODR, and I think that kind of chimes with the general thoughts. When you speak to practitioners about the new measures that have been forced on it, digital signatures, electronic communications, not having to have physical copies of court papers and so on, and you speak to people and they say, oh well, now that we've done it, we can't possibly go back to the way it was before because we've proven that it can be done this way. And it sounds like maybe there's an element of that as well, which is once people see the benefits of ODR, that notwithstanding they're not forced to use it now because social distancing is maybe not in place, they're still nevertheless seeing the benefits and choosing to use it. That's interesting. You mentioned online mediation, and I'd like to maybe focus in particular on that, just given the time available. I know a lot of clients, in-house lawyers, watching this will of course already be familiar with traditional face-to-face mediation, but maybe less so with online mediation. So I'd be interested to explore that with you. But maybe before we get onto that, on the topic of mediation, be interested in your take on this, which is that I've always been a big proponent of mediation. I can see the real benefits to it, but nevertheless, when it's either proposed or suggested that parties take their disputes to mediation, there's still a perception by certainly not all clients by any means, but some clients, that agreeing to mediation or proposing it is a sign of weakness and shows a lack of strength in their own case. So I'd be interested in your take on that and what your answer to that would be.
Well, I agree with you. There are obviously some people out there that still consider mediation as the soft option, and that's not just clients, of course. I suppose as a starting point, the first thing I told my clients, when I was a solicitor, is that never once have I considered an offer of mediation as a sign of weakness. You and I know that that's just not the case. Another thing I always tell my clients now is that all negotiations have one common feature, and that's the need for both sides to declare victory. And finding a way for the other party to declare victory while securing a victory for yourself can be very challenging, far more so than leaving a judge to decide your fate. So I think it's important to remember mediation is just a facilitated negotiation. And I suppose this perception of weakness seems to come from a misconception that by being open to negotiation, you believe that you're going to lose in court. But the reality is that no solicitor ever tells their client they will win in court. That's not a given in any case. And the reality is that negotiation and mediation are an opportunity to find a better outcome. Now, better might mean a better net financial outcome, or it might mean that you get what you need and you restore an important business relationship. I suppose the point is there needs to be a winner and a loser in court, and a judge can only grant certain orders. But in mediation, it's possible for one party or both parties to get an outcome which better meets their needs. I'm sure you've heard the analogy, and I use this still a lot to this day, the analogy about two children fighting over an orange. So if you go to court, one child will win the orange. If you split the difference, which is rarely a wise result, then each child gets half the orange. What if you discover in negotiation or mediation that one child wanted the orange peel and the other wanted the orange segments?
Yeah.
And I can tell by the way you're nodding, you have heard that before.
Well, I've heard a variation of it. I haven't heard that particular analogy, but I think I'm going to start using it now. and I mean, people these days, Zoom, Teams, that sort of thing, will be familiar with doing things that they would ordinarily done face to face online. How does, in terms of the practicalities, Rachel, how does online mediation work? Maybe talk us through that.
Yeah, so it's the first thing to say is it's really simple and easy to use. I think a lot of people hear online dispute resolution and think, that you need to be an expert in technology, or it's artificial intelligence or machine learning or cognitive thinking and all that stuff. And there are developments going on at that end of the scale. But when I talk about online dispute resolution and what Squaring Circles does, it's, online mediation is just a mediation facilitated by technology. So you absolutely do not need to be an expert in technology. Far from it. I'm not, and neither are any of the Squaring Circles panel members. So the process starts in effectively the same way as if you were looking to instruct a mediator for face-to-face. The difference, I suppose, is that you will require to set up a username and a password to access a secure online platform. Now, this is the platform that Squaring Circles uses. You're absolutely right that lots of businesses are doing mediation on Zoom or other platforms, but we use a platform called Modron Spaces, and the reason we use that is because it's a very secure platform. So video calls are end-to-end encrypted, and the ability to upload documents and share files is also all encrypted. So you log into a platform in the same way as you would log into your online banking or to your emails, and everything in relation to the dispute is on that platform, so you can find things quickly. So for me, when I was setting up the business, I wanted to use a secure platform because that's what I would have wanted if I were the client or if I was the solicitor recommending online mediation. Another really important feature, which I really liked about this platform, that once the mediation is at an end, you can delete everything that's on the platform with the hit of a button. It's a hard delete of the files and the case, so that absolutely nothing exists once the case is finished. So that for me was a really important feature. So once you've created your username and password, then the mediation is conducted through the platform, and different spaces are set up within the platform to replicate the physical rooms that you have in a face-to-face mediation. So there'll be a space for all the parties and their representatives, legal representatives. If they've got expert witnesses, they can be included in that space, which is like the room, the virtual room. And then there will be a space created for each team, I suppose, party A and party B. And you can create, as many different spaces as you like. You set them all up in advance, and it's very easy for the parties to move in and out of the rooms. They click on one button to end their involvement in one room, and they click on another button to start meeting in a separate room. And it's really that simple. The mediation then just progresses in the same way as it would face-to-face. One of the benefits is the flexibility, because you don't need to have that full traditional mediation day. So you can run the mediation over, say, 2 or 3 days in smaller kind of chunks, which I find parties quite like. 12 hours in one room is very, very draining. By the time you get to the kind of negotiation stage of the mediation, everybody's exhausted. So by doing it online, you have that flexibility. There's not that pressure to have the mediation day, because you don't need to get everybody in the same physical room, and people don't need to travel to be there.
Yeah, and I'm assuming it works in the same way as a traditional mediation, which is that you could be in your own room. If you choose to see your opponent, the other party, you can then elect to join the sort of larger room and sort of move around quite freely in that sense.
Yeah, that's one of the good things about mod-on spaces as well. So, for example, on Zoom, which is also very, Zoom is very user-friendly for mediation. There's no denying that. But the parties for Zoom have to be moved by the mediator electronically. So the mediator has to click various buttons, and then you have to just hit an accept, which moves you into a different space. With Modron, the parties have control themselves, so they can leave one room and then go into another room. But they've always only got access to rooms they're allowed to be in, because it's set up like that in advance. So there's never a risk of a party appearing somewhere that they shouldn't, because the rooms, the people that are assigned to each room is all set up in advance. So what it means is that you and your client, if you do a mediation through Modron Spaces, you and your client can end your participation in the space with everybody, and then you two can go off and meet in your room by yourselves. And when you're ready, you can put a message on there's a messenger channel for each space. You can say, we're ready for you, mediator. And then the mediator, I can just join on and add myself into that room.
Okay.
So it's the functionality is amazing. And it's really, really simple to use. I'm not a technology person at all, but I am an efficiency person, and I really liked when I tried various different platforms. I really liked what this one offered.
Okay, now that's interesting, and it's good to hear about the security and the confidentiality, because on Zoom I haven't ever shared any documents other than a quiz answer sheet, but you do wonder where that goes into the ether once you leave the room. So the fact that there's this hard delete of any what will be confidential, commercially sensitive potentially documentation is a real advantage, I think. So we touched on some of the advantages there, the flexibility, the security, and so on. Generally, are there any other advantages that you see in terms of online mediation over the traditional face-to-face method?
Yeah, so it's convenient. We've touched upon that. It's efficient. We've touched upon a flexibility and cost effectiveness as well. I think the main benefit we've not spoken about is probably early engagement. And I think the benefits of online mediation means that it can literally start the next day, assuming that the mediator is available. Then you can just just progress with mediation straight away. And early engagement is really important. Disputes, the quicker you can get a facilitator or mediator involved in a dispute, the better, in my view, because the parties are less likely to be entrenched. So if you're waiting to book this mediation day, face-to-face mediation, you could be waiting weeks to get all the parties available. You know, if parties have to travel from England or the north of Scotland or even internationally, which is not unusual, you're looking at months down the line. So I think, you know, in addition to all the benefits we've already mentioned, that for me is the kind of key benefit.
Yeah, and I think that I certainly sense that there'll be more of a willingness as well to have that early engagement, to have this online, dispute resolution method, whether it's arbitration or mediation, because people have seen that online ways of conducting business works. You know, whether it's board meetings or other sorts of meetings that clients are partaking in. So there may be that general more of a willingness than there might have been before. Now that they're seeing the benefits of the online technology.
I mean, that's right. I mean, I certainly feel that online mediation is changing. It's not just moving a face-to-face practice onto Zoom. You know, and we're all pretty new to this. So we're learning things as we go along. But certainly the importance of that mediation day, the feedback I've had is that people like the idea that the mediation is not this mediation day, the pressure that's, you know, put on everybody for this one day. And by bringing a mediator or a facilitator, which, you know, there's very, very similar roles and processes, but you can actually get them involved early on, and it can the mediation can evolve. It can be put on hold. People can go away and get information. Having the involvement of that neutral at an earlier stage can actually mean that whilst you don't get a resolution straight away, that you can bring, you know, everybody can go away and think about things, do further investigations if they need to, and, you know, you can reconvene in a week or 2 weeks' time, and the mediator can be involved in ongoing, facilitated negotiation if that's what's in the best interest of the parties. So it offers so much flexibility, and it's, you know, there's definitely, it gives solicitors different ways and different tools, I think, when they're thinking about how can they resolve this dispute for their clients. And I definitely think that flexibility is the key to that.
No, absolutely. No, that's really interesting. Turning to the future, Rachel, be interested in what you see as the future of dispute resolution beyond COVID-19. Do you think the last few months have meant that, you know, the changes we're seeing, these new platforms, new ways of resolving disputes, do you think dispute resolution has changed forever?
I definitely think it has. I think the pandemic has changed so much about how we do business, you know, how we socially interact. And I don't think disputes is going to be any different. There's so much commentary just now about how the crisis has brought competitors together, you know, particularly in the construction and property industries, for example. And, you know, I see collaboration will be the key to economic recovery. I even read something in the press last week about, you know, employee ownership of businesses, you know, which is just another form of collaboration, and how that's going to improve economic recovery. So my hope is that collaborative mindset is carried over into disputes, and also how dispute resolution services are delivered. I think we'll continue to see a shift towards, you know, value-based billing. But I also think that business owners and leaders will be empowered by the ability to take greater control over how their disputes are managed and resolved. I heard an international mediator say last week that the golden age of mediation is upon us, and I think he's right about that. I definitely don't think we will be going back to how we did things before.
Well, given all the advantages that we've talked about in terms of, you know, mediation, it's certainly pointing in that direction, that's for sure. I'd also be interested, Rachel, you know, in terms of what the future is for squaring circles going forward.
Yeah, so there's a lot in the pipeline for squaring circles, and I'm very excited about the future. I only started this in October last year, so it's still relatively new. There are plans to grow the ODR panel to cover additional specialisms, and I hope to grow the wider team in the next 6 to 12 months. The best part is probably how much I love what I'm doing. I certainly feel like I've found my calling.
Yeah, I think you have it. As I mentioned at the beginning, your passion for ADR was always obvious when we worked together, and you couldn't have picked a sort of more exciting time to launch it. Is exciting the right word? I'm not sure, but certainly.
I'm not sure if it is either.
I'm not sure, but you know what I mean. It's an interesting time for dispute resolution going forward, and these are all very timely services in the current situation. So, Rachel, listen, that's been a joy to speak. Thank you for coming on, and good luck with the business.
Thanks very much, Stuart.
Thanks.
I'll speak to you soon.
Thank you.